All rise. Your Honour, today we have a hearing in the matter of Salam Advocates and Legal Consultants and Kele Contracting LLC, CFI 009 of 2017. The claimant is represented by Global Advocacy and Legal Counsel, led by Sharon Larkin and assisted by Nazanin Esfania. The defendants have not entered an appearance.
Yes, good morning. I'm very sorry to keep you waiting. I'm afraid something
that's absolutely
on my
fine,
desk.
Your Honour.
Yes.
Your Honour, if I could start with just a housekeeping matter and check that you have both of our bundles in front of you.
Yeah, I've got two bundles. I've got your skeleton. Thank you very much.
Wonderful. Your Honour, we've also submitted a table that looks like this, that details...
Now, what is missing from your skeleton is what you call the...
a schedule of disputed matters.
A sort of schedule. I haven't got that.
Can I hand up a revised version to Your Honour, please?
Thank you very much. Yes.
Your Honour, this is the claimant's application for immediate judgment.
Yeah.
The claimant is Salam Advocates. Salam is a UAE law firm that specialises in cases before the UAE courts, before the police and the public prosecution. The defendant is its former client, Kele Contracting LLC.
What does the defendant do? How does it end up in the wrong end of so much litigation?
I would like to know that as well, Your Honour. I think there are 81 matters that my client is representing them in. I'm aware of other matters as well.
I mean, what's the business?
It's some kind of a consulting company in relation to construction, I believe, Your Honour.
Oh, right.
Yes.
Right. I think it's very bad or very unlucky. I'm not quite sure which. Yeah.
I can only speculate what the problem is.
Yeah.
Salam was instructed by Kele in relation to approximately 81 matters, as I said. Those were all before the UAE courts, the police and the public prosecution's office. It's essentially a very straightforward claim. It's for recovery of outstanding professional fees, which Salam says it is due.
Yes.
They were appointed pursuant to a professional fee agreement, which was dated the 22nd of November 2015.
Yes, I have that.
That's
Was that the only contract, or was it replaced by another one?
There was an original contract in 2014,
Okay.
Your Honour, when Kele originally instructed Salam, and when they were not quite sure what the nature of the cases would be and what sort of quantity they were talking about. In 2015, that was revised. And if Your Honour would like the reference, that's at Bundle 2, tab 107B, and it's...
Sorry, bundle which?
Bundle 2.
2?
Yes. Tab 107B.
Yes, hang on. Yeah, you know.
And the page is 584.3.
Sorry, what's the point?
Point 3.
Sorry, bundle 2, tab 117.
107.
7, I'm sorry, my fault.
So there's 107A, 107B.
Professional review agreement, I have that, yes.
Yes.
Now, you recite the principal terms in your skeleton, don't you?
Yes, I do.
Yeah.
Your Honour, I understand that you're in somewhat of a hurry this morning, so
I mean, in a way...
unless you need me to take you through certain points, I'm not proposing to do that.
Right. I mean, possibly the best way, as you say, they've had every opportunity of responding to this claim. They've afforded no defence. They're not here today. They've indicated no basis for challenging these claims other than the points you make in paragraph 19 of your skeleton, that the cases didn't exist, or there was some mistake,
Or that my client is not entitled to payment because judgment was handed down after suspension.
Post termination.
Yes.
all those points look pretty hopeless, indeed more than hopeless. I'm just trying to think the best way of dealing with this. One possibility is for you to just take as an example one of the disputed matters. Otherwise we're going to spend a lot of time here. And just take me through it.
Precisely, Your Honour. And
so that we can see how it all works for that example.
Yes.
And then...
For each of the three
give me one example of each of the 3 points.
I'm happy to do that, Your Honour. And I think you'll be able to see as well from the table...
Thank you very much.
...that all of the items that we specify,
as well.
they're cross-referenced to witness evidence. So the first one that I can take you to, Your Honour, is the first matter in the table, Qatar General Insurance.
Yes, I see that.
At paragraph 10 of the defence, Kele says that there was no such case. Mr. Al-Zari, who is a partner at Salam Advocates, has put on a very detailed witness statement, and at paragraph 208 of that witness statement, he refers to an email from the claimant to the defendant confirming attendance at a court hearing and advising of the next hearing date. And if Your Honour would like to turn that up, that is at Bundle 2.
Bundle 2?
Tab 96B. Page 537.6.
I have it.
And if you can see around halfway down the page, there is an email from Ms. Sawad Jalad, who was a PA, I believe, to the CEO at Kele, to Salam Advocates, referring to documents to be submitted in relation to that case. And if you see from the subject heading, it's Kele Contract LLC versus Qatari General Insurance. Your Honour, if you go over a few pages to 537.8, you'll see an update there, which actually begins on the previous page, from Salam Advocates, again to Ms. Sawad, updating in relation to attendance at a hearing.
Thank you.
So confirming that they've attended. There are other references I could take you to, Your Honour, but I think you have the point that the case was very much in existence.
Thank you.
So that's one example of a matter where the defendant has said that no case existed. There are similar documentary references to all of the other cases they have referred to in that regard. Your Honour, if I could take you then to item number 7 on the table. And I can give you an example of a matter where Kele says that Salam was either negligent or did not run the case properly or did not follow instructions. So in its defence at paragraph 17, in relation to National Link equipment rental, Kele says that a settlement agreement was not filed in court, which is what led to attachment proceedings being lodged in the local courts against the defendant. Your Honour, the relevant paragraphs in Mr. Al-Zari's witness statement are at paragraph 52 to 67. At paragraph 53 of the witness statement, Mr. Al-Zari refers to the settlement having been undertaken by Mr. Mahabi, who is the legal counsel, in-house legal counsel for Kele Contracting, and that it was actually Mr. Mahabi that was arranging the settlement, arranging the delivery of the checks. Now, Salam was given the checks, but they were not able to be accepted by the court because they had not been addressed correctly. And Mr. Al-Zari says that thereafter, Mr. Mahabi of Kele Contracting collected the checks and arranged matters directly with National Link Equipment. The reason that execution proceedings were continued is referred to at paragraph 55 of Mr. Al-Zari's witness statement, and it was because the defendant's checks bounced that the execution continued. And at paragraph 63, Mr. Al-Zari refers to the court informing him that the reason that the execution had continued was that the balance due on the settlement amount had not been paid, and therefore vehicles had been attached. As soon as the checks had cleared, Salam then took all steps to have the attachment proceedings cancelled. And if Your Honour would like to turn up Bundle 1, tab 28. And page 104 and 105.
Yeah.
This is a translation of an extract of the case proceedings from the local courts.
Right.
And if you see the first entry on page 105, you can see that Salam Advocates has applied and all the procedures are to be cancelled and the file to be kept until the complete payment.
Yes.
So that, we say, Your Honour, demonstrates that Salam was taking all steps possible to abide by its professional obligations. And again, as Your Honour has noted, the evidence from Mr. Alzari has not been challenged by the defendant.
Thank you.
Your Honour, if I could then ask you to turn to item number 16 on the table.
So 16, did you say?
Yes. And I can give you an example of a matter where Kele's defence is that because the judgment was handed down by the court after suspension, that therefore, for some reason, Salam is not entitled to its 100% of its fee. Item number 16 is the matter of Gateway Golf Transporting.
Yes.
And you can see at the defence at paragraph 20.4, Kele refers to the claimant only being entitled to claim 50% of its fee because the judgment was issued after the suspension of services. Mr. Alzari deals with this at paragraph 127 of his witness statement through to 131, beg your pardon, through to 134. We can see, I mean, Your Honour, it's a fairly silly type of defence in any event. The timing of the payment is one thing, and entitlement to be paid fees is another. And we can quite clearly see from the items here that Salam has continued to provide services up until November 2016 in relation to this case, despite having suspended services for new matters from June 2016. And if you look at the last entry in item 16, we can see that a judgment was issued on the 10th of November, and that has in fact been updated to Kele by Salam.
Well, thank you very much.
And I think all of the other matters are along similar lines in each of those three categories of defence, Your Honour.
Well, I think that's probably all I need, unless there's something you'd like to draw my attention to.
No, Your Honour, I don't think there's anything further I wanted to draw your attention to. I don't think I need to take you through the provisions for immediate judgment. The only thing we would like
if you
from
want
you...
your costs, do I have a schedule of that?
I don't know if it's made it to your file. It's been filed.
Probably has. Oh, here we are. I've got it now.
Oh, you have it?
Hang on.
The other
7,000 dirhams. That is?
Check the total.
Yeah.
Yes, that's correct.
Thank you.
Your Honour, the other point that I would like to raise with you, we have requested interest from the period of 13 June 2016, which is when
let me just understand that. You want interest on the capital sum, which is...
on the outstanding amount, yes.
About 1 million or so.
Yes.
First of all, what rate?
Well, pursuant to the Commercial Code, Your Honour, the maximum interest is 12%, but that's obviously at the discretion of the judge.
Wish I could get 12%. Yes.
I would like to get 12% on our fees as well when they're outstanding.
But I agree. It encourages payment. But okay. So what's...
We would be seeking interest, Your Honour, but I'm happy to leave that at your discretion, what would be the appropriate amount. I understand in the local courts it's quite regular for interest to be awarded in the amount of 9%.
Sorry, what was the figure again?
Generally in the local courts, 9% is considered to be fairly standard.
And as from what date?
We are asking from the 13th of June 2016, which is the date of suspension of services.
13th of June 2016.
16.
Okay. Cost, thank you very much. That's extremely helpful. Thank you very much.
Do you need any further submissions
I
from
think
me?
that's all I need. Thank you.
Thank you very
Can
much.
you give the judgment? A very quick one. This is an application by the claimant, Salam Advocates and Legal Consultants, for immediate judgment in respect of outstanding fees said to be due from Kele or Kele Contracting LLC, the defendants. The background is pretty straightforward and is spelled out in a witness statement of Mr. Mohammed Al-Zari, which we have in our bundle, being the Chief Executive Officer of the senior partner of the company, of the law firm. The monies are said to be due pursuant to legal services provided to the defendants under the terms of a professional fee agreement dated the 22nd of November 2015. The basis upon which the fees were to be calculated is spelled out in that contract and varied according to the nature of the work being conducted and the category of case. In broad terms, the fees were to be 7% of the claim amount for civil cases with a minimum of 15,000 dirhams and a maximum of 45,000. Dirhams 15,000 where a settlement was concluded prior to judgment, a lump sum of 30,000 in any criminal case, and 50% of the terms added that the 50% of the professional fee was payable within 45 days of the defendant providing the claimant with the instruction to represent it, and the balance payable after the first judgment of the court. The sum at stake is dirhams 1,172,484.71. The claimants also seek interest and costs. The defendant company did file a defence and counterclaim in April last year, but have in effect taken precious little participation in these proceedings since that time. Messrs. KBH Canoon were engaged to represent the defendants during the course of the summer of 2017 and filed an amended defence and counterclaim. That counterclaim funded because the filing fee was never paid. There was then a somewhat unsatisfactory demand by the defendants for further disclosure. The defendants have found no evidence whatsoever, either in accordance with the order made on the case management conference or otherwise, and they are not represented here today, having received due notice of this hearing. There was an indication at one stage in October of last year that the defendants wanted further time to file evidence, but they have never filed any application in support of that, and accordingly the court intends to proceed on the material that's available here today. The criteria for immediate judgment are spelled out with in convenient form in G of H Capital against David Lawrence Haig, 2014 DIFC CFI 020, in a judgment of Justice Roger Giles. And I won't solemnly read through those principles, which are well known. As I say, the defendants have not seen fit to file any evidence, have not seen fit to attend, and have not furnished any support for the defence which they filed. The defence relates to about 20 of the various matters on which the claimants were engaged, and raise three potential defences. First, that the relevant case didn't exist at all, or the claimants weren't ever instructed. Secondly, that in some respect the claimant was negligent or didn't provide an adequate service. And thirdly, that the judgment in the particular matter was handed down after the claimant had suspended his legal services under the contract, and therefore, for some reason, was not entitled to claim 100% of his professional fees. Ms. Lacan, who appears for the claimant, has most helpfully provided the court with a table of these disputed matters, numbering 20 in total, in which she has set out the identity of the claim being made against the defendant, what point is being taken by the defendant in regard to the fees being charged by the claimants, a cross-reference to the witness statements of Mr. Alzari dealing with the individual items, and helpfully cross-references to our extensive bundles. She has taken me through three good examples of the disputed matters. An example of the case where the claimant is said to have invoiced for a claim that didn't exist. Another one, an example where the claimant was said to have acted negligently, and a third one where it was said for some reason the claimant wasn't entitled to claim 100% because the services continued after the contract was terminated. I'm quite satisfied, as indeed Ms. McCann puts in her skeleton argument, that these defences are entirely devoid of merit. And I do not propose to hesitate in granting judgment in relation to the claims that are being advanced. There is no need for me to solemnly go through all 20 examples of the various issues. It's sufficient for me to say that the examples that have been tendered demonstrate that the unreliability of the defendant's defence, and since it's wholly unsupported by any evidence, and wholly unsupported by any submission on their behalf before me, it is safe for the court to proceed on the basis that the claim is a valid one. So, I give judgment to the claimants in the sum of 1,000,000, I've lost the figure, 172,484.71. There will be interest on that figure as from the 13th of June 2016 at the rate of 9%. In addition, the claimants are entitled to their costs, which are contained within a schedule which is put before me. I do not detect any reason why those costs are not both legitimately calculated and fair in terms of rate. And so there will be a judgment for costs in the sum of 467,629.71 dirhams. Now, is that all you need?
Your Honour, I believe that is all we need. Thank you very much.
Thank you very much indeed. And thank you for your bundles, which must have taken a lot of work.
They did, Your Honour, but
And one day I'll
very
discover
well.
what Kele do. Heaven knows what they do. Okay.
Cause trouble only.
Thank you very much.
Thank
All
you, Your
rise.
Honour.